Reggie on the line with a question from Gunnersville. Hi, Reggie. Thanks for calling. What's your question tonight?
How are you doing? Thank you for taking my question.
Thanks for calling.
I have a question about the Alabama lemon law. I have a Chevy Spark that I purchased in September, and I pretty much had to prove to the dealership that the car shuts off in park, has transmission issues. I've made over 80 videos, and I've actually taken it to the dealership and showed them how it shuts off actually there in the dealership. I guess with a lot of the paperwork I've signed, and a lot of people don't realize that when they buy a new car, that you sign paperwork saying that you have to go through the Better Business Bureau first, which I'm doing. But my question is, what are my options if the Better Business Bureau states that I don't have a claim? And the reason I ask that is, per the Alabama lemon law, you have to notify the dealership before the first 12,000 miles. Well, I did. I would go in there and talk to them. They would work on the car and have me see if it's fixed, but they never created a work order at that time.
Okay.
And the first work order they finally did create with it, I think it was 12,335 miles.
Well, they may have played that just right.
Yeah,
huh?
and I'm pretty sure the dealership knew that was the case. It's like anything else. If you have evidence, you have testimony, you can go in and say, look, I alerted them to this problem before 12,000 miles, then you could get the benefit of the lemon law. Otherwise, you could look at filing a breach of contract claim.
Well,
breach of warranty claim?
The Alabama lemon law, as it's more commonly referred to, is very complicated. I've only had, in 12 and a half years of practicing law, I think I've only had a couple of people that it actually applied to, and I've referred them to other attorneys to handle those matters because it's so complicated. But I know that there is one aspect of it. When you purchase a vehicle, you sign an arbitration agreement.
Yeah.
And most used car dealers are doing that as well. So from now on, when you place that dealership on notice, they're probably going to claim, hey, you've got to take me to an arbitrator. You can't sue me. And it's binding arbitration. Whatever the arbitrator decides is what you're going to get.
Right. You're going to take, loosen the limits, of your, the limitations of what you could, prove in court going through arbitration. But that would be the other step. You could file for, your complaint and then go through arbitration for breach of warranty or, breach of fitness for a particular purpose. But, obviously you're fighting GM. That could be a big war.
We've got